Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 22nd August to 27th August 2022. In first important news, the Supreme Court has held that inherent power under CPC can only be invoked when no alternate remedy is available. In the case of My Palace Mutually Aided Cooperative Society versus B. Mahesh, the Supreme Court has noted some important observations with respect to the exercise of power under Section 151 of CPC. The court has noted that Section 151 can only be applicable if there is no alternate remedy available in accordance with the existing provisions of the law. Such inherent power under 151 cannot override statutory prohibitions or create remedies which are not contemplated under the CPC. This provision cannot be invoked as an alternative to filing fresh suits, appeals, revisions, or reviews. In second important news, the Supreme Court has held that no prosecution under PMLA is possible after the accused is acquitted of the scheduled offence. In the case of Parvati Kolar versus State by Directorate of Enforcement, the Supreme Court has noted that a person acquitted of a scheduled offence cannot be prosecuted under Prevention of Money Laundering Act 2002. The court has said that the offence under Section 3 of this Act is dependent on illegal gain of property as a result of criminal activity relating to a scheduled offence. So, if the person is finally discharged or acquitted of the scheduled offence or the criminal case is quashed by the court of competent jurisdiction, there can be no offence of money laundering against him under this Act. Before we move further, we have launched CLAT PG 2023 capsule course which will provide you with the preparation of basics of all subjects, of relevant recent case laws, and also practice questions and mock tests. So if you are interested, you can check out the details of the course from the link given in the description box. Moving on to the third case, Section 3 Clause 2 of Benami Transaction Prohibition Act has been declared as unconstitutional. In the case of Union of India versus Ganpati Dealcom Private Limited, in a very important judgment, Section 3 Clause 2 dealing with punishment for entering into Benami transaction of the Benami Transactions Prohibition Act of 1988 has been declared as unconstitutional on the ground of being manifestly arbitrary. A three-judge bench in this case has declared that Section 3, when read with Section 2A and Section 5 of the 1988 Act, are overly broad, disproportionately harsh, and operate without adequate safeguards in place. Lastly, the Supreme Court has held that blacklisting order of contractors without specifying a time period is not sustainable. In the case of Mrs. Chauhan Builders Rai Bareli versus State of Uttar Pradesh, the Supreme Court has noted, in the context of blacklisting of contractors, that one cannot be blacklisted for life. The order of blacklisting, to the extent that it has not specified the period, cannot be sustained. This brings us to the end of our update. If you like this video, please like and share and subscribe to our YouTube channel.